Welcome to this webinar, and thank you for your time to attend it. This webinar is recorded, and the recording will be posted on the RECIEL YouTube channel sometimes next week. Before we begin, I will begin with thanks. First of all, thanks to Ginevra for bringing us together, for taking the initiative, and to all our distinguished speakers. Also, thank you to our three partners, the Cambridge Centre for Environment, Energy and Natural Resource Governance, the European Society of International Law, who, by the way, invites you to consult the brochure, which is posted in the chat to see more about their activities, support for early career researchers and how to join. And also to RECIEL, the Review of European, Comparative and International Environmental Law. A warmest thanks also to Misha Lim and Tejas Rao, who were the two people who very generously and brilliantly helped with the logistics. I'll now very briefly introduce the speakers, and then I'll say how we plan to proceed and on what we hope to focus during this webinar. All the speakers speak in their personal capacity. First of all, Margareta Wawrinka Singh may not need a long introduction. She co-led the legal team for Vanuatu, who was, as you probably know, at the very beginning of this entire and several years long campaign to make this advisory opinion happen. So together with Julian Aguan, she was the co-lead of the legal team, and she's a professor at Amsterdam Law School. Unfortunately, Margareta has to leave the webinar after answering some of our questions, but we very much appreciate that you had the time to join us today. Then Haro van Asselt is a professor at Cambridge University, and he participated in the proceedings on behalf of the International Union for the Conservation of Nature. Dr. Leslie Ann DUVIC-PAOLI is reader at King's College, and she was also part of the legal team for the African Union. Then Joie Chowdhury is a senior attorney at the Centre for International Environmental Law and very tirelessly worked with the World Youth for Climate Justice Movement and the Pacific Islands Students Fighting Climate Change. Ginevra Lemoli is co-editor-in-chief of RECIEL, of the Review of European Comparative and International Environmental Law, professor at the European University Institute in Florence, and she was also part of the legal team on behalf of the African Union. I myself, I'm Evelyn Schmid. I'm a professor of public international law in Lausanne in Switzerland. I did not directly participate in the proceedings, but I did use them for teaching for over the last 3 years to explain to undergraduate students how students sometimes can have a real impact in international law. And otherwise, I'm fond of research on everything related to state responsibility, omissions, and all things related to the implementation of positive obligations. Now, how will we proceed today? We don't have much time to introduce the advisory opinion, but very briefly, I could summarize by saying that very many superlatives have been used to describe it. It's the first time the International Court of Justice said anything explicit on climate change in the largest proceedings in the court's history. For many states, it was the first time they appeared in The Hague, and the court gave us 140 pages with unanimous findings, plus 6 declarations and 6 separate opinions. And it did so a bit more than a month ago. So the superlatives range from historic, monumental, groundbreaking, landmark, powerful, remarkable, radical, and robust. And I would personally add that the court did not play the diva. The court said a lot of things, of course, some limitations in this advisory opinion as well, but the court did answer the questions, and it did so by leaving many doors open to many different actors. And for reasons of time, if I could just draw your attention to one paragraph, all of them are written with a lot of wisdom, but the last one is particularly beautiful, where the court says that in front of an existential problem of planetary proportions, a court of law will be important, but it will not be able to resolve the problem on its own. It's an all hands on deck approach that is needed. And many different kinds of actors and mechanisms will be important to implement the various obligations. And that's what we hope to focus on. So where from now, what can the different actors make of this advisory opinion? For the Q&A, you can ask your questions in the Q&A chat, and we will do our utmost, just as states should implement the obligations, we will do our utmost to take as many questions as we can, but of course we have limited time at our disposal. I now hand over to you, Ginevra, for introducing the first question.
Thank you, Evelyn, and thank you everyone for joining us today for this important conversation on the ICJ advisory opinion on climate change, which really provides us with a legal basis to identify and against which identify a conduct responsible for climate change, which is not assumed by the court as a lawful one. And also that an opinion that shapes and reshapes the way we think about international law, environment, and climate change. Just a quick note on how we structure the discussion. We will first invite one speaker to reflect on one point of the analysis, and then of the legal analysis of the court, and then also invite other panelists to intervene and share their reflections with us. So let's jump straight into the content of the opinion. One of the most important aspects of the opinion is the court's strong reliance on climate science. This is specifically also significant given that in many jurisdictions also courts have been hesitant in engaging with scientific evidence, and also at a time when misinformation about climate change remains still present. And another key feature of the opinion is the court's interpretation of the relevant conduct. While many states focused mainly on emissions, the court took a broader view, taking into account both production and consumption. So as Evelyn mentioned, we're fortunate enough to have Professor Margareta Weverinckesing with us. So Margareta, to begin, can you walk us through how the court arrived at these conclusions with regard to both its assessment of climate science and its broad interpretation of the relevant conduct, and what implications they might have for implementations also by states, in your view? Thank you.
Yes, thank you very much, Ginevra. And let me dive straight in. So what stands out immediately in the opinion, of course, is that the ICJ very explicitly recognized the Intergovernmental Panel on Climate Change's reports as the best available science on the causes, the nature, and the consequences of climate change. In an unprecedented move, and very interestingly, the court even convened a special meeting with leading IPCC authors to brief the judges on key scientific findings prior to the hearings. I think it's fair to say that this strong reliance on science had very real effects on the opinion's scope. The scientific evidence allowed the judges to very confidently link greenhouse gas emissions to concrete harms, such as extreme weather events, sea level rise, the slow onset events, and the rapid onset events, and to attribute contributions to, or to acknowledge that contributions to climate change can be attributed to specific states. Even though the court, of course, did not take the step to actually attribute emissions to state, but noted the possibility. The court rejected arguments that climate harms are too diffuse or collective to assign responsibility, and instead it pointed out that that modern science can quantify each state's share of global emissions. Of course, that also drew on data for current and historical emissions that many participants in the proceedings had provided to the court. And so this reliance on science enabled the court to cut through uncertainty, essentially, and to treat climate change not as a policy issue, but as a matter of legal obligation grounded in evidence. And that then also enabled the court to take a far-reaching view of the relevant conduct at issue in the proceedings. So when it interpreted the General Assembly's questions, the section that does that sets out the material scope of the court's inquiry. And there it states that this material scope, and here let me quote directly from the opinion because this is critical, encompasses the full range of human activities that contribute to climate change, including both consumption and production activities, end quote. So what the court then does is defining the relevant conduct in question. And here, let me quote again, it is not limited to conduct that itself directly results in greenhouse gas emissions, but rather comprises all actions or omissions of states which result in the climate system and other parts of the environment being adversely affected by the anthropogenic greenhouse gas emissions. So that means that any state act or failure to act that contributes to harmful climate change falls within the purview of the relevant conduct and the proceedings. So that is not just the act of emitting carbon, but also upstream and downstream activities that lead to those emissions. And indeed, the court also states explicitly in the section that defines the territorial scope of the inquiry that there is no territorial limitation on this inquiry as such. And here it points at the transboundary nature of the climate crisis. So again, it's a very factual view that the court here takes, which is extremely helpful, of course, in getting the most effective possible kind of legal response to this matter, or interpreting the law in a way that makes it effective, so to say. The broad construction of the relevant conduct mirrors what the Republic of Vanuatu had submitted. So in the Vanuatu in its written statement had defined the relevant conduct as encompassing acts and omission of individual states and of a specific group thereof that have resulted over time in a level of anthropogenic greenhouse gas emissions from activities within their jurisdiction or control which have interfered with the climate system and other parts of the environment to an extent which amount to at least significant harm to the latter. So the ICJ's view closely mirrors this understanding. What is crystal clear is that it considers the full spectrum of state behavior driving climate change, from burning fossil fuels to extracting and subsidizing them. So arguably the court even goes beyond what was submitted by Vanuatu. What is really crucial also from a practical point of view, the courts reject any artificial loopholes that might exclude major emitters or producers from scrutiny. It noted that many participating states and organizations agreed that obligations to protect the climate system or to protect against climate harm do not rest exclusively with consumers and end users, but also include activities such as ongoing production, licensing and subsidizing of fossil fuels. And of course, the court was able to confirm that also because Judge Cleveland had posed a question to participants. Participants had responded, so there were very explicit responses to that question on the record. So the opinion then confirms, in the context of state responsibility, that a state's failure to take appropriate action, including curbing fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies may constitute an internationally wrongful act attributable to that state. And
Yes.
the wrongful...
Thank you, Margareta. If you could just conclude in 1 minute or half a minute, so we can give the floor to also other panelists to add a few words also on this point.
Okay, I'm sorry to take too long. So, well, let me conclude then with in an action-oriented way. So that this broad and science-backed interpretation really gives new momentum to efforts at every level to demand accountability and stronger action. So the challenge is really to operationalize these findings, including in these very specific points on production. And I'm sure that the discussion in the webinar will provide more inspiration on that journey. So thank you very much.
Thank you, Margareta. Indeed. So I would like to ask whether also other panelists would like to add some reflections on what Margareta just discussed, or on other aspects of the advisory opinion that you deem relevant with regard to the relevant conduct. And also, as Margareta mentioned, not many submissions included the definition of the relevant conduct or made references to a specific conduct. So the court took inspiration from and really almost quoted the approach that Vanuatu adopted in its written statement. So just asking panelists whether some other panelists would like to intervene. Haro? Yes, please feel free.
Right, thanks. Let me start by congratulating Margareta and in a way thanking her as well and the Vanuatu team, because I guess we wouldn't be sitting here at this webinar talking about the advisory opinion if it wasn't for the years of concerted efforts to make this happen, to make it a reality. So just wanted to put that up front. So for me, like the paragraph 94 on the relevant conduct and the expansive interpretation of the relevant conduct, I think is very important. And it reminded me a little bit of one of my colleagues' recent work, Jorge Vinuales, who was also external legal counsel on the Vanuatu team, who's been writing a lot recently on what he frames international environmental law being the law of negative externalities, or the law of side effects. And I think what the court is doing here is showing that international law or international environmental law can be more than that. It cannot just, it can go beyond just addressing the greenhouse gas emissions that arise from economic activities, but it can, and the court is arguing, should also look at the core economic activities, including fossil fuel production, that give rise ultimately to these emissions. And therefore, I think what the court is doing is really showing that when we're framing and looking at the problem of climate change, we need to look at just the narrow framing of territorial greenhouse gas emissions, as many states, or well, many states, like as some states have been arguing in the proceedings, but also as many states have been arguing in the context of the UNFCCC for many years. And in that sense, I think the court legitimizes alternative approaches that might look at overconsumption in general, that might look at fossil fuel production in general, that might look at deforestation. All of these activities are clearly relevant for addressing climate change. They're not part of the core of the Paris Agreement as such. I guess what the court is telling us is that actually, yes, it should be considered, and approaches, including international efforts to come to new agreements, such as the Fossil Fuel Non-Proliferation Treaty, can actually be seen as addressing these issues and is relevant. So I just wanted to flag that and in a way echo what Margaret was already saying.
Thank you, Haro. I would like to simply also thank Margareta. I know that you have to leave, so thank you for your time, for your reflection on this point, and we'll continue also the conversation on the basis exactly of this, of the court's assessment of the science and relevant conduct. So we'll now move to the second part on the applicable law. So I would like to now turn to our also next speaker, Harro again. Harro is Hutton Chair of Climate Law at the University of Cambridge, and he also participated in, as also Evelyn mentioned, in the proceedings, although today is here in his personal capacity. And Harro, I would like to hear your thoughts on the implications of the court's broad approach to the applicable law. The court went well beyond climate treaties to define the applicable law, and also can be said that judicialized some aspects of the climate treaties. By also covering the role of decisions in conference of the parties, also discretion in NDCs. So could you walk us through how the court reached these conclusions and what you see as key implications, both for climate litigation and climate negotiations as well? Thank you.
Right, thanks, Ginevra. I'll try and address as much as I can in the allotted time. So I guess what many already know and what many already have talked about is that the court was very, very clear in rejecting what some countries were arguing is the lex specialis argument, right? Basically saying that the UNFCCC, the Paris Agreement, constitute lex specialis. So basically, if we comply with our obligations under these treaties, we will have fulfilled our duties. And the court clearly rejected that. And the court not only rejected it, it also made it very clear that applicable law includes customary international law. It includes other areas of international environmental law, human rights law, law of the sea. So all of these other areas are part of the applicable law or the most directly relevant law, as the court called it. So in doing so, I think what the court is importantly doing is adopting an unequivocally systemic approach to international law on climate change that, in my view, neither diminishes the Paris Agreement, nor does it ignore the broader normative environment within which the Paris obligations are situated. So all of these sources of law, like the bodies of law that I mentioned, according to the court, all have to inform each other, is the wording that the court used. Now, I can see implications for this both in litigation and in negotiations. In litigation, I would imagine that strategic litigation against states will, to the extent that they haven't done so yet, will very clearly draw on a broader set of international legal sources, including not just international human rights law, but arguably also international law of the sea, with last year's advisory opinion by the International Tribunal for the Law of the Sea also giving litigants further guidance. And I think this can strengthen the hand of plaintiffs, particularly in those countries that have a modest tradition towards international law, to where international law can have some sway and influence. In the negotiations, I think that the advisory opinion strengthens the argument to take into account the objectives and obligations of other treaties, for instance, in the design of financial or market mechanisms that may have a negative impact on human rights or biodiversity. At the same time, although the normative systemic integration is important, of course, a key challenge will also to work on an institutional integration. So we should not, as parties to the Paris Agreement, not just be looking at the objectives and the obligations of the Convention on Biological Diversity, but we also need to think about mechanisms of how to make sure that those biodiversity concerns are effectively integrated in the decision-making process under the Paris Agreement. Now, while the court does take a broad approach to applicable law, I would have liked to see the court maybe take an even broader approach for at least considering one area that I think was certainly relevant, which is the area of international economic law, which is kind of bracketed by the court and not further discussed. Judge Cleveland, in her declaration, does discuss international investment law, but that's roughly the extent of it. And I think the court could have at least followed Judge Cleveland in saying, for example, that the interpretation of investment treaties must be informed by states' obligations on climate change under international law, as the court has elaborated them. And likewise, I think the court could have followed a country like St. Lucia, which pointed out in its written submissions that international trade law play a role in restricting fossil fuel subsidies. But these are minor quibbles with an overall impressive opinions. On to the second part of your question, which is on the Paris obligations and the role of COP decisions. Let me say a few things about each. First, I think the court makes a lot of important findings about the Paris obligations. Like it elevates the 1.5 degree goal as primary to the primary goal of the Paris Agreement. It finds that states don't have unfettered discretion when setting their NDCs. It finds that states, their NDCs need to ultimately taken together be capable of addressing the 1.5 degrees goal, and states need to adopt domestic measures that are capable of achieving their NDCs. All of these are very, very important points that taken together, they are clear calls for ambitious NDCs and for more ambitious domestic laws and regulations that can achieve these NDCs. The time, though, is a little bit challenging because parties were due to come up with their new NDCs on the 10th of February this year. Many haven't done so, but I also think it would be quite optimistic to think that many countries are now completely revising their NDCs, which most of them are likely to come in by COP30 in Belém in November. So I would not expect many to revise them by that time based on the advisory opinion. However, they may update them at any point afterwards. So I think domestic pressure through domestic litigation and through parliaments will be important to make sure that states come up with new NDCs also after they have submitted their NDCs 3.0, as it's called. And last but not least, your point about COP decisions. Clearly, the court made an important point here about COP decisions being potentially seen as subsequent agreements under Article 31, paragraph 3A of the Vienna Convention. It uses reasoning to ultimately say that the 1.5 degrees goal was the primary temperature goal. But I don't think the court was as clear as it could have been in saying when these decisions express agreement in substance, in the language that the court uses. Here we have hundreds of COP decisions with lots of language, and all of this, we're now wondering, like, to what extent might this be seen as subsequent agreements that is relevant for interpreting the Paris Agreement and UNFCCC obligations. And I think that's quite unclear, but also looking forward, I think one of the effects might be that states might be quite cautious when developing new decision texts. If they know that domestically or by other states, they might be seen as ultimately interpreting their primary obligations, it might be that they will be even more reluctant to agree on COP decision text, and therefore consensus might be even more difficult. And we'll see this play out or not at COP30 in Belém in a few months.
Yes, exactly. We'll see how also states will interpret the approach given by the court. So I would like to also invite other panelists to intervene if they want to add something on what Haro just mentioned, on other points of the advisory opinion. I don't see any. So perhaps Leslie-Anne, yes?
Thank you. No, just a quick point to basically build on what Haro was saying about the other multilateral environmental agreements that are mentioned, because I think in the proceedings there, like the Convention on Biodiversity or desertification were not really at the center of the discussions and the proceedings, but it was quite interesting to see that the court actually does spend quite a lot of time, especially, for instance, when we compare it with how much space it devotes to human rights that were really at the center of the proceedings. We do see that the court does spend quite some time on other multilateral environmental agreements. And the analysis might be slightly descriptive, but at the same time, it might have implications for the other COP processes. So not only the climate COP, but also for biodiversity and desertification. I think we can see this advisory opinion also having an impact on other environmental negotiations.
Thank you, Leslie, also for this. And Joie, you would like to also add, on this, please.
Yes, very briefly, and complementary to Haro's points, because which were great. Thank you, Haro, for that. I think one of the areas of applicable law that is very critical in terms of how this will be used going forward, since you wanted to focus on practical implications, is where the court touched on obligations of states under the law of the sea, and especially on obligations of states in relation to sea level rise. because one, the situation is really dire and international law does not, in at least an uncontested way, address it sufficiently. And we are seeing a lot that is coming up around it, whether it's the ILC report on sea level rise, where there's a huge diplomatic push from the SIDS across multilateral fora. There is legal interventions being discussed in terms of strategic litigation. So in terms of, even though the court was quite succinct, I think the language in paragraph 362 and paragraph 363 in terms of like really unpacking it and taking it forward on maritime boundaries and territorial integrity and statehood will be very, very critical, especially for small island states.
Thank you also for this reflection. And so now I would like to hand the floor back to Evelyn, also to guide us through the next part of the discussion. We're a bit late, apologies. We're running just 5 minutes late. Thank you.
Thank you so much to everyone. Now we are, well, we've done 2 out of 4 questions, and it's a good moment to pause just for me to congratulate really all the speakers and everyone who was involved in the entire process behind this advisory opinion, because there's so much dedication, time, energy, sleep, and deadlines before Christmas break, but not only Christmas break, that went into this. Really warm congratulations. So the next question is for Leslie Ann, and it's not a question, it's more a package of a question on different aspects, all related to the stringency of the due diligence standard, the legal status and relevance of the duty to cooperate, and if you have time, some of the human rights dimensions, notably the right to a clean, healthy, and sustainable environment. What do you make of this group of aspects of findings in the advisory opinions? What are your most important takeaway points from this group of aspects?
Thank you so much, and thank you for the invitation. It's great to be here today. So very briefly, I think we can say that the court ended the debate on the applicability of a prevention principle to the climate problem. It very quickly said that the climate is part of the environment, and therefore the duty to prevent environmental harm is applicable. I think this has implications because the court took really an aterritorial approach to the duty to prevent. It's not looking at the environment of other states or at areas beyond national jurisdiction, like in the wording of Principle 21 of the Stockholm Declaration. Instead, it's very much focused on the fact that prevention needs to apply to global environmental concerns. So this has implications, of course, for the climate system, but also for other environmental problems that might not have been seen to fit squarely within the dimensions offered by the prevention principle, be it biodiversity loss, that tends to be a more like localized problem, deforestation, as Harro has already mentioned, or plastic pollution that has very complex causation and territorial implications. The court said very clearly, building on its own jurisprudence as well as the ITLOS advisory opinion and the scholarship that has developed in the last decade or so, that the duty to prevent is an obligation to act with due diligence. What is interesting is that I think it's given due diligence, really, it's strengthened the role of due diligence, because due diligence is not only applied in relation to the customary duty to prevent, but also to actually assess compliance with treaty obligations. And that's quite interesting because due diligence has sometimes been criticized for being too vague to hold states into account, for instance. And what the court is doing here is actually using this flexibility that is afforded by the due diligence standard to ensure that we can hold states accountable under the Paris Agreement and other treaties for their own climate actions. It's also saying that thanks to due diligence, we can individualize the responsibility of states. So the arguments that this is just the action of one state that contributes little to the climate problem is not going to be accepted anymore. And this is building on domestic litigation cases that have recognized the same thing. So the court has adopted the kind of well-rehearsed position on the link between the level of risk and the expected level of due diligence. The higher the risk, the higher the standard, and reaffirming the affirmation of its laws that the standard has to be stringent. It's also building on the content of due diligence in terms of the need to take appropriate measures in light of scientific and technological information, including international rules and standards, and in light of different capabilities. Just a few comments on all of this. I think an interesting statement is the fact that due diligence and the appropriate measures necessary to discharge due diligence include adaptation measures, which I think is quite interesting. We see in this advisory opinion an emphasis put on adaptation as well, put at the same level as mitigation obligations. And it's quite interesting that the court considers that adaptation measures now are part of this duty to prevent. It's conceptually interesting because actually the nature of these measures tend to be quite different. The type of harm is not the same. We have harm to the climate system, whereas we have harm from the climate system in case of adaptation. The territorial impact is different. Mitigation tends to benefit all, whereas adaptation is much more localized. So I think this will have implications in terms of strengthening the adaptation obligations of states. We all know that most states are not doing enough in terms of adaptation, so this can have quite a significant impact for expert bodies. At the moment in the UK, the Climate Change Committee is working on adaptation, for instance, and this is strengthening the role of adaptation and obligations in states. Haro has already mentioned the impact that technically non-legally binding norms can have, and this is reaffirmed also in relation to due diligence. So we're not hiding behind this veil of formal international law anymore, but these non-legally binding norms are contributing to the due diligence standard. On cooperation, the court says that this is not a moral requirement anymore, or only a moral requirement or only a diplomatic endeavor, but that cooperation becomes a legal obligation. So, of course, this has significant impacts in terms of international negotiations and in terms of finance and technology transfers that are included under this duty of cooperation. At the same time, the court considers that cooperation is not only these technological and financial transfers, but it also relates to emissions regulation. So we have a duty of cooperation that is not only a kind of procedural endeavor, but has a substantive content, and that can be linked to the collective temperature goal. Very briefly, in terms of human rights, I think the court actually takes a much more minimalist approach compared to what it does in terms of due diligence. It recognizes the adverse effects of climate change on the enjoyment of human rights and the fact that the right to a healthy environment is essential for the enjoyment of other rights. But we know that it remains very vague on some more contentious issues. Is there actually a human right duty to mitigate or adapt to climate change? What is the status of the right to environment? What is the extraterritorial scope of some human rights obligations? The court remains quite vague. So what really are the implications of the advisory opinion on the human rights? It's, I think, reaffirming a body of law that has been developing in the last decade or so. Is it going to make significant changes? I find it difficult to foresee. I think states that do not recognize the right to a healthy environment will see themselves reaffirmed in their position that this is not a customary rule of law, and are unlikely to recognize the right at this moment. And I'll just stop here. Thank you.
Thank you very much, Leslie. I'm sure we'll come back to some of the aspects of your answer later on. I would like to directly hand over now to Joie, who will get the question basically on the consequences of the court's findings on consequences of climate change obligations when states fail to take sufficient action. So question B in the General Advisory, in the request of the General Assembly. So what do you make of the court's findings on legal consequences? And feel free to pick either on loss and damage, or also we have already some questions in the Q&A. A number of them relate to corporate accountability. So over to you, Joy.
Thank you, Evelyn. And thank you, Leslie, for those really rich remarks. Despite the really short time, Evelyn, I promise I will keep it brief. I do want to start with broader context because we get so much pushback on this in the real world. Accountability is really central to a climate justice approach. And for decades, high-emitting countries and corporations have knowingly profited from fossil fuel policies that have worsened the emergency, while frontline communities have endured devastating loss and damage with little redress. And loss and damage is such a sterile term, right, for what is at stake, which is the lives and livelihoods of present and future generations, entire ecosystems, identities and cultures of entire peoples. I mean, the injustice there is unconscionable. Crucially, thus, one of the two questions before the court, which Evelyn mentioned, was what are the legal consequences for states where they, by their acts and emissions, have caused significant harm to the climate system and other parts of the environment. And despite efforts by polluters to evade responsibility, the court rejected every legal loophole, reaffirming that loss and damage already endured must be recognized and repaired, not as charity, but as legal obligation. And the court's conclusions on the question of legal consequences will carry great weight because the issue has not been addressed in sufficient depth in law and policy to date. In terms of forms of legal consequences, the court was clear that engaging in climate destructive conduct in breach of climate obligations may give rise to the entire panoply of legal consequences provided for under the law of state responsibility. So we're talking about the cessation of harmful conduct, assurances of non-repetition, and the provision of full reparation. And cessation and assurances of non-reparation entails halting wrongful conduct, and may also require revoking administrative measures or legislation that is not consistent with international law. And where damage has materialized, state must make full reparation, whether by restitution, which is restoring to the prior condition before the violation. So, for example, restoring ecosystems or infrastructure, by compensation for financially accessible loss, or by satisfaction, such as by formal apologies or public acknowledgements. Some of the separate opinions, such as the ones from Judge Yusuf, Judge Pandari, and Judge Sebutinde, suggested the court could have provided more specific guidance, even more specific guidance on legal consequences. And on forms of reparations, it is very instructive also to go back to the proceedings and see the arguments from several climate frontline nations, which were indeed very specific in types of forms they would consider as remedies, including how reparations may include systemic measures, for example, debt cancellation to addressing colonial legacies. One of the issues that Margareta touched on was conduct. So this is really critical for the legal consequences piece as well, because the court robustly defined the conduct breaching climate obligations and triggering legal consequences. The ICJ has affirmed that the conduct in question, as Margareta mentioned, is not the emission of GHGs per se, but the breach of the full range of applicable conventional and customary obligations pertaining to the protection of the climate system from significant harm. And the court in particular has spotlighted climate-destructive corporate conduct, vital given the disproportionate contributions of corporations to the climate crisis. They did not specifically, I saw there was a question in the chat on the UNGPs, unlike the Inter-American Court, mention UNGPs, but they very much call out states' responsibilities under law to regulate private conduct. And as you mentioned, as Margareta mentioned, the court has affirmed that a failure of a state, and I am going to read this language because it is such important language for our fight against fossil fuels and for climate justice, that the failure of a state to act against fossil fuel production, fossil fuel consumption, fossil fuel exploration licenses, or fossil fuel subsidies may constitute an internationally wrongful act triggering legal consequences. Judge Cleveland and Pandari were even clearer in their joint declaration that fossil fuel emissions overwhelmingly drive the climate crisis, and phasing out fossil fuel dependence is a core obligation under both treaty and custom. The court further emphasized, as we've discussed, that states must regulate private actors. So in terms of implications, put simply, climate polluters that pursue business as usual fossil fuel production and use, let alone expansion plans, should expect to be held to account. And I will not go into details, but those of us who work to counter the fossil fuel industry know that it is a very tough landscape at the moment. So the science is settled and now more strongly affirmed in the law, and policy and action must follow suit. The ruling in and of itself will not bring the fossil fuel era to an end, but how it is used in litigation and legislation and diplomacy and campaigns will give it bite. And the language especially, and I agree with Haro here, who mentioned the Fossil Fuel Non-Proliferation Treaty, very much has implications for developments in that context. Very quickly to conclude, to pivot to the question of litigation, notably the court has clarified that climate obligations are erga omnes in nature, essentially duties owed to the entire international community, allowing for states, any state, not only those directly harmed, to invoke another state's responsibility. So to the question whether the ruling strengthens the basis for interstate litigation, yes, it does. And beyond interstate, we can expect the case to have ripple effects in courts across jurisdictions in national, regional, and international levels. And because the court's assessments on legal consequences was not in concreto, given the nature of the case, litigation may support in practical application and responding to some of the questions the court left for fact-specific future contentious proceedings. In fact, we've already seen key elements of the advisory opinion used in a South African case against Shell on offshore deepwater drilling. And one thing is certain, that until big polluters pay up for the climate harm they've caused and phase out fossil fuels, the struggle for justice will continue in the legislators, on the streets, and also, yes, in court. So Evelyn, I'll hand it back to you.
Thank you very much, Joy. You've mentioned the South African litigation. I just want to add for our audience here that tomorrow the Swiss civil court in the canton of Zug will have a hearing in the case of the Indonesian fisher people who litigate against Holcim. For now, this case is at a very procedural level, and I wonder to what extent the advisory opinion will make it into the proceedings. So stay tuned for that one as well. Now, I'll hand back over to Ginevra to moderate the Q&A. I see we already have a number of very, very interesting questions, and I'm looking forward to all the various answers as well.
Yeah. Yes. So thank you, Evelyn. Thank you, everyone, also for your for sharing your reflections on previous questions and points. So we now have around 20 minutes, 25 minutes for our Q&A session. So thanks for those who actually already shared their questions in the chat. We'll try to address as many as possible. But I suggest to also group some of them who actually cover related areas that have been addressed in the advisory opinion. So one question is related to to science and the fact that the court refers to IPCC report and scientific sources, and it asks whether this provides some normative value to science and international law. And we could also relate it to considerations also and questions on the relevant conduct. And there are two in particular that could fall under this. One is a question on the role of, for instance, of this advisory opinion in potentially affecting negotiations to regulate sectors such as international shipping or aviation or even the military, which remains outside mention, although there are some references in Cleveland Declaration on the on emissions in armed conflict. So I think the way the court framed the relevant conduct potentially could also allow an evaluation also on this. And then COP decisions, so as the applicable law. potentially, I think Harro could address these different points on science and the relevant conduct, given that you also pointed before to paragraph 94 and the role also of COP decisions. And in particular, with regard to the COP decisions, one of our participants asked whether important GST decisions agreed at COP28 could be legally binding. So, and then of course I leave the floor also to the others, but we could start with Harro with one of the points that you would like to cover, and then we move to the others.
Yeah. Right, it's really an excellent set of questions, both in the Q&A, but also summarized by you, Ginevra. Let me start with briefly on the science. I think on the one hand, it is not surprising that the court has put the IPCC front and center. And in a way, it's really telling how the court, like at all times, just stays focused on only the IPCC, doesn't bring in other reports and scientific studies. And I think there's something to be said about the cleanliness of that, right? Like, so it's very clear. This is the most authoritative statements, also, of course, in the way which the IPCC reports are produced. It does mean, of course, that there might be other studies which are relevant. For example, the International Energy Agency report on net zero by 2050, which the court leaves to decide, even though there might be relevant messages in that. But I do understand that. What I think is a bit more challenging in terms of the implications is that the court doesn't always clarify what the science entails. And I think the most telling part there is with the 1.5 degree goal. Right, like, so I put the 1.5 degree goal as the primary goal. But then what does that mean in terms of pathways? What does that mean in terms of conduct? It's not just about, let's say, the appropriate measures from a due diligence perspective, but we also need to think about, well, what are the particular pathways? Because it matters a lot if a country is pursuing, or if the global community is pursuing 1.5 degrees with or without overshoots, with or without extensive use of negative emissions technologies. And all of these important scientific questions, which are to some extent dealt with also in the context of the IPCC, are kind of avoided by the court. And I think they will come back in domestic litigation to the extent that we see international litigation will also come back. But the court doesn't give us that much of a handle in terms of how to use that science. Then on the question on COP decisions, and I think the particular question was like, well, is now the entire decision on the global stocktake, so decision 1 CMA5, is that legally binding? I think my short answer is no, unfortunately, in a way, but I think the answer is no, it's not legally binding to the extent that we can argue that it's a subsequent agreement, right? It will inform the interpretation of the primary obligations, right? So Article 4, paragraph 2 of the Paris Agreement, and therefore it can be of importance. And likewise, the global stocktake outcomes have to be taken into account in NDCs, right? So there are different provisions in the Paris Agreement that also spell that out. But it doesn't mean that, for example, transitioning away from fossil fuels now has become a legally binding obligation by the court. Like that would be maybe what some people might want, but unfortunately that is not yet the case. Having said that, I think we can have a broader discussion about, well, under which circumstances can some of this language inform the interpretation of the primary obligations, inform what is highest possible ambition, inform what is progression. So I'm not saying that all of this is not legally binding and therefore irrelevant. No, I think it is relevant, but it's not as straightforward as saying, well, now all of these provisions that are in this decision will have become legally binding.
Thank you. Thank you very much for also your considerations on. Is really an interpretation of the approach that the courts gave. So there can be conflicting considerations, but I do think that you're right in pointing out that we need to also be not to launch ourselves in assessments that may ultimately lead to belief that everything is binding, or and whatever is included in the advisory opinion. So in this case, I think I would like to move to another part of the also of the panel discussion that it relates more to the principles and the applicable law. Although I'm giving the floor to Leslie Ann, because we have two questions on the principle of common but differentiated responsibility and respective capabilities. One question refers more to whether we do see a change in the approach given by the court or not, compared to what we knew before about the principle. And already the fact that the court addressed the principle is already important. And second, whether the prevention will be softly implemented because some states will claim low capacity. So also, Joie, probably you could also address this question as you wish. You could perhaps, Leslie, and if you want to start, and then Joie could also build on this point.
Thank you so much. And I think it's good to mention also principles, environmental principles, because the court in its discussion of applicable law does make a list of applicable principles. At the same time, I think, as Haro has also mentioned, it says very little about how these principles should in practice be implemented. So how do they impact the interpretation of the obligations that are then discussed is very unclear. And I think this is true of common but differentiated responsibilities, and relatedly it's true of sustainable development. And the whole discussion about the fact that international economic law, for instance, has been overlooked is also linked to the fact that sustainable development is surprisingly not really at the center of this advisory opinion, although this is what the previous case law of the court was really about. How do we apply this idea, this concept of sustainable development? And this is also at the center of the UNFCCC and the Paris Agreement. And so as a result, it tells us very little about the practicalities of the implementation. How do we balance these environmental imperatives with the economic realities? There's very little about this. On differentiation, yes, thank you for asking these questions. I think they are very, very important. And again, we are told that the prevention principle and due diligence have to be interpreted in light of differentiation, both historical responsibilities and current capabilities. What the court says importantly is that there's not only a developing distinction, but that there are different levels of capabilities, and that therefore not being a developing state would not justify a delay in taking climate action or complete exemption from taking climate action. So every state, irrespective of their level of development, has to take some action. So I think the court is very clear about the fact that there are not only two categories, but at the same time, for instance, by looking in detail at the obligations under the Kyoto Protocol that very much has this division, it's also reinforcing this dichotomy in terms of developed versus developing. Should I give the floor to Joy, maybe?
Yes, and perhaps I'll also add then another consideration, that is related to another question. So we have two questions on states' accountability for the action of private actors, and also so whether you probably, Joy, you could elaborate on this aspect also of states' accountability for the action of private actors, but also to what extent also the principle of common but differentiated responsibility may play a role, if you want, of course, or if you prefer to focus on one dimension, is fine, of course.
Thank you. And, thank you, Leslie, for those reflections as well. I think CBDR is always very contested in how it works out in practice. But I think, one of the court provides some light, and it builds on ethos that it is common for everybody, but there is differentiated responsibility. And I think the approach taken in equity, how we handle equity in human rights jurisprudence, actually really sheds light. We have long dealt with this in economic, social, and cultural rights jurisprudence in what an equitable approach to human rights law looks like. And I think given this kind of cross-regime fertilization that the court has so powerfully demonstrated in, its applicable law and under A, I think we should be drawing more from human rights application in the way that we think about how CBDR applies in practice, but very much agree that the practical implications and the politics and how it plays out in certain spheres like COP. There was also this particular part of the opinion where they talk about the emerging economies, right? Like that all developing countries are not cut from the same cloth. And I think that there are considerations of that, how that plays out in terms of the climate treaty regime as well. So I don't think it'll be simple, but the court has shed important light, and I think it will now, be taken forward. I've mentioned corporate accountability in my remarks. So the one last thing I'll close on is military. I saw that was mentioned, and it is something that I think is really important. The court didn't touch on it, yes, but it wasn't brought up in a lot of the proceedings, right? It wasn't brought up in a lot of the written submissions. I think Palestine's proceedings brought it up, but submissions brought it up. So I think in a way, like the court does respond to what the arguments placed before it is. I do think, like Ginevra mentioned, that Judge Cleveland's declaration is very helpful in understanding the different parts of it. I also wonder that there is this kind of block we have that does it have to be mentioned specifically for the findings to apply already to military emissions in different countries, right? The court is very clear what states' obligations are in relation to climate change, and some of those findings, in my eyes, would very much apply to how states are conducting themselves in terms of military operations. But obviously that is to be tested out, so I'll stop here.
Apologies, I was muted. Thank you for addressing also this additional consideration on, well, the linkages with equity, indeed, and in especially also in human rights fora. Now, we have a question that points to somehow a consideration that is raised in Judge Nolte's declaration on the symbolic legal consequences that would be ultimately provide litigation, so that would be provided by litigation. So one may say from the point of view of developing countries, there could be a possible strategy that one could visualize in terms of the fact that the courts stresses vulnerability, the fact that CBDR is recognized, historical responsibilities are recognized by the court as important, as well as the recognition of the right to a clean, healthy, and sustainable environment. So there are some points that I would see as a potential content, and ultimately also, and last but not least, also the recognition of the obligation to cooperate, financially assist, provide technology transfer, capacity building to developing countries. So from a litigation point of view, there could be strong points that states could also raise in litigation. I'm just wondering whether you have what are your considerations with regard to Nolte's declaration and Nolte's points that is raised by one of our participants? Feel free if you want to, one of you want to intervene, Arro or Joie.
Yeah. So I read Nolte's declaration as a cautious one, right? Like, so okay, like have we opened the floodgates kind of comment? And I think it both, in my view, underplays the advisory opinion and overplays it as well. It underplays the advisory opinion in the sense that it suggests like the only way you could get value out of this advisory opinion if it forms the basis for further litigation, which then contentious litigation, which then might achieve certain results or not. I think the value of the advisory opinion, we can maybe touch upon that at the end as well, is much broader than simply how states are going to be instrumentally using it in future litigation. But it also overplays, maybe the advisory opinion overplays also the role of international litigation, in my view, as, let's say, trying to solve the problem of getting finance for loss and damage, or solving the problem of holding polluters to account. One ruling by a court, even the International Court of Justice, is not going to change that. Well, it's not going to solve it. Let me rephrase that. It is part of a broader movement, a part of a broader puzzle, and Joie here is, of course, in the midst of it, where we see domestic litigation, where we see domestic political parties, where we see youth movements. We need to think about all of these pieces of the puzzle that are trying to achieve this goal. And international litigation is going to play its part, for good or for worse, but it's going to play a part, and it needs to be seen in an overall context where what, let's say, a country is going to put forward for loss and damage finance is not just going to be determined by whether it's been held responsible by the International Court of Justice. So I think, again, like it's a very, I understand where Judge Nolte comes from, but it's kind of an overly narrow view of, let's say, here the International Court of Justice is called upon to either hold the state responsible for not meeting its obligations or not. It will still be important in any such finding, but it will not solve the entire problem of making sure that states stop producing fossil fuels, or that states start giving enough funding for loss and damage. So again, I think that Judge Nolte maybe suggests a bit too much pressure on the shoulders of the ICJ when it comes to contentious litigation.
Thank you. Evelyn, would you like to add a consideration on one of the questions that have been raised also in the chat? Otherwise, I also have another question, as you wish.
For reasons of time, well, we would like to give in any event, and then maybe you can add your question, Ginevra, and then we just give it to all our speakers. But we would like to give them a chance for a short closing statement. And there's one question, a very difficult one in the chat that could be a suitable invitation to do that. And you add yours, Ginevra, and then you only get 1 minute each speaker to do with those questions what you see, what you think is possible. So there's one question from a participant asking what you think would be the most important strategic step that lawyers or academics can now take to build on the advisory opinion in the next few years, especially in this context of difficult times for public international law. So maybe Ginevra, if you can add yours, and then the speakers should feel free to maybe just mention 1 or 2 aspects with which they would like to close this webinar.
Well, given that it is a very broad question, so my question was a rather narrow one, in the sense that for me is something that was missing was a consideration of the right of people to self-determination. I didn't really, although like the many submissions included it in length, in written statements as well as in pleadings. But the courts also said very little about it. It confines it to sea-level rise, statehood, and human rights. So I was wondering whether you also have a reflection on that. But first, a priority to our participants and and their questions. So perhaps you can add that in your final remarks. Thanks.
Maybe I can start with a difficult question. I think I'm not probably going to give you like the answer that you were hoping for. The first thing is there is always going to be possibly a distinction between what lawyers want to see as lawyers. Of course, we want to see another case at the ICJ, and what will actually have and make a difference on the ground. And these might not necessarily be compatible. The second thing is, as lawyers, you will necessarily have different perspectives and different rules depending on the country where you are, where you work, etc. So a lawyer in the UK is not going to, I think, going to take the same steps and have the same practical impacts as a lawyer in the global south, for instance. Personally, what I see, as someone who's based in the UK, what I see as the kind of main obstacles in the UK to, let's say, implement the advisory opinion, I see first of all cuts to development aid that are quite significant in the UK and in Europe, which will have an impact on climate finance, etc. So this is going to be quite an obstacle to the implementation of more ambitious climate assistance. So I think this is something that lawyers might be looking at. Where is development aid going? How can we actually increase it, etc. And because we live in very constrained fiscal and budgetary environments. The second thing in the UK is this question of the right to a healthy environment that is not accepted. And this is again for lawyers to think about, would that actually make a difference in the beyond the symbolic and the strategic? Does this actually make a difference if we have or not have this recognition of a right to a healthy environment?
Thank you, Leslie. Perhaps Haro or Joy, if you would like to add some final remarks, if you have any, or...
I actually really loved your question, Ginevra, because the right to self-determination is one that I deeply care about, both in terms of what it means for states, also in terms of what it means for Indigenous peoples. I remember when Julian argued that, I was in tears. It is such a difficult right to argue in court, and it is so essential in the climate fight and the fight for climate justice, and it is so under-recognized. And I know it seems like it hasn't been sufficiently addressed, and it hasn't, in the opinion. But the first treaty that the court cites in terms of applicable law is the UN Charter. And the UN Charter clearly has, it's right up there, right? The right to self-determination. The human rights treaties have been mentioned, and it's Article 1 across the two, the ICCPR and the ICESCR. So Indigenous rights has been separately mentioned. It has been specifically mentioned in terms of the sea level rise issue. So yes, I do wish the court had addressed it. Many states brought it up in their proceedings, but I do think there are hooks there that we can definitely use. And then to end on what are the actions that we can take from to really breathe life into this advisory opinion. I actually think I love litigation. I am a litigator, but I don't think it is the answer to the climate crisis. I think it can unlock specific pathways. I do not think we have the timelines. So strategic litigation, where it can actually work with other processes, with diplomatic processes, with scientific findings, that's where we can really bring power. And the three areas that I really think we need to move on is fossil fuels. We really need to make more progress on ending the era of fossil fuels. And I know there are people in this call, including Haro and others, who do incredible work on fossil fuels. I think this does give us power to do stronger work on, and it builds that architecture out. The architecture and loss and damage, we are so not going to get on the world of reparations through litigation, right? But it unlocks pathways and it builds that momentum to get effective multilateral mechanisms potentially. I mean, the FLRD is a bit of a mess, but it puts us on that pathway, and that pathway is so critical. And then protecting the science. Right now, science is under attack. What we're seeing coming out of the United States is very difficult. So the IPCC, the new, the cycle is coming up, really protecting the science and building on all of these cases, kind of strong affirmation of how central best available science is in informing states' duties will be critical. But I'll stop here.
Right. If I can then also indeed like answer the big question, very tough, but very important indeed. So I guess I'll start with echoing Joy first, with a focus both on fossil fuels, and I would say particularly on no new fossil fuel projects and no fossil fuel developments to start with. Like for me, that's the most obvious message, particularly with putting 1.5 degrees as the primary goal. That's a clear message, which I think not only litigators can and will use, but indeed also legislators should use. Right? Like so, this is something that particularly in countries in the global north, legislators should pay heed to, and they can. And again, so for me, that will be one of the priorities and one of the strategically important acts to follow first. The second, like of course, when we're thinking about the tough times that we're in terms of international law, we obviously look at the United States. We look at other countries which might not respect the international rule of law as much as we would like to see. But I think still the majority of states does respect the international law, wants to respect the international law. And here I think the ICJ gives very clear guidance in what they need to do. Right? Like so rather than trying to convince the United States to try and do more on climate change, on plastics at the moment, why not focus on those states that actually have put forward and have said also to the ICJ, yes, we agree, right? Or yes, we agree that we need to do our utmost and focus on those states and bringing them together. So that also might mean in the context of international climate negotiations that we need to see flanking agreements that simply do not depend on consensus, right? So this might be outside of the Paris Agreement as such, but still in support of the goal of the Paris Agreement. So I think it is time to also look for these countries that do want to move forward. How can they build coalitions outside of the Paris Agreement, knowing that they will not get consensus on an ambitious agreement otherwise?
Excellent. So thank you for all your reflections, for your also insightful answers. I think we won't be able to cover all the questions, unfortunately. So I really apologize to those who also added their questions in the chat, but we try to really cover and touch upon all the main legal issues in the advisory opinion. I'll just briefly take 2 minutes to conclude. So in our conversation today, we discussed many different aspects of this advisory opinion that was adopted also unanimously by the court, and that really identified the conduct responsible for climate change as an international wrongful act unless it displays certain standards of and reflects certain standards of due diligence. The role of climate science, the definition of the relevant conduct have been at the very basis of this opinion, and allowed also the court to ground the answers to both question A and question B. With regard to the applicable law, the court rejected the lex specialis argument and also adopted a broad approach, although, as also Haro flagged, it leaves out economic law. However, it clarifies certain important dimensions. First, the 1.5 temperature goal as the agreed primary target, and also judicialized aspects of climate treaties, although still there are dimensions that could be also, we will see also in practice how they will play out, such as the role of COP decisions and whether they are to be considered binding as subsequent practice. As also Leslie Ann mentioned, due diligence standards become also a way of addressing treaty obligations, may also strengthen adaptation obligations. With regard to human rights, definitely human rights govern the relevant conduct, and the court recognizes the right to a clean, healthy, and sustainable environment. as well as the principle of common but differentiated responsibility and respective capabilities as a principle cardinal that will, and a landmark principle that will also allow potentially and ground developing countries' claims. Then the last but not least, also loss and damage that may be addressed through state responsibility. Then our panelists really have clarified how the opinion is much more than a judicial document. It's really a potential catalyst for action by states, negotiators, civil society, in policy discussions, the future resolution that will be adopted by the UN General Assembly, also at the UNFCCC Secretariat or the Conference of the Parties, and also in international regional negotiations, also of economic nature. And inevitably also in litigation context. And the challenges of climate change demand nothing less than collective, informed and sustained action. Also remembering that it was a group of students that at first started the process that led to the advisory opinion. Climate change is, however, not only a legal problem, and the court makes this clear towards the very last paragraph of the opinion. It requires contribution of all fields of human knowledge, and in the words of the court, also a satisfactory solution requires human will and wisdom, changing our habits and comforts, our way of living. So with this, I would like to conclude, thanking our speakers for sharing their expertise with us, our dedicated coordinators, Michelle and Tejas, for ensuring a smooth running of the webinar, our partners, CIEL, CEENRG, as well as RECIEL, and all of you in the audience for engaging with us. Join us again in our next RECIEL Insider webinars. So thank you again. Have a wonderful day and see you soon. Goodbye.